We'll hand over to Claire to introduce this webinar today. Oops.
Great. Hello.
Hello. You're on.
Great stuff. Thank you very much, Corinne and Adrian. So good afternoon, everyone. As Corinne said, I'm the head of the Business Awareness Unit for the Export Control Joint Unit in the Department for International Trade. Our role in the Business Awareness Unit is to inform exporters of their obligations in terms of UK and EU export control policies to ensure you are compliant with the laws and that you make the right licence application at the right time. Firstly, let me say how encouraging it is to see just how many individuals and companies alike have registered for this training session, and many more will be able to download the recording. During the current COVID-19 pandemic, our priority in the Export Control Joint Unit has been to ensure continuity of strategic export control licence processing. You will all hopefully have seen the communications we've issued in this period via our Notices to Exporters service on changes that we have made to, for instance, compliance visit handling, the acceptance of electronic signatures as opposed to wet signatures on key documents, and the unlocking of key forms to enable you to process them online. Another of the key announcements we had to make was the cancellation of our popular classroom-based training programme. As an organisation, we are constantly looking for improved delivery of our messages, and we've had to adapt to the fact that our classroom courses held in London and the regions were cancelled. I hope that you will have dialed into the first online training session in May on technology controls, delivered by our esteemed trainer, Adrian Bond. Adrian has been the Export Control Joint Unit Training Manager for over 5 years, and both his engineering background and experience as a technical officer in ECJU has enabled him to constantly review, refine, update, and successfully deliver the training material, now in webinar format. So without further ado, I introduce Adrian Bond.
Oh, thank you, Corinne and Claire, for introducing the webinar platform and topic. And welcome to this bite-sized introduction to strategic export controls. For those who haven't met me before, as Claire mentioned, my name is Adrian Bond, and I normally travel the country running export awareness courses. This webinar will introduce a topic new to many of you, or something you've been struggling to understand. I hope to explain the terms used, the items that are described by the controls, some of the more unusual controls that are in place, and how you can then obtain licenses if needed. Claire, Michelle and I will be keeping an eye on the questions as they come in, and there'll be time at the end to ask further questions. I'll be covering various aspects of the current laws, as they are of July 2020, but they are subject to change. Your businesses and the items you work with are all unique, which is great. So as I cover the general aspects of export controls, you need to look further into them to see how they affect your business. And if your activities appear difficult to fit into these controls, then please get the extra advice needed to ensure that you comply with the laws. Nothing I say today will absolve you of that responsibility. The Export Control Joint Unit is the licensing authority for strategic export controls in the UK. You cannot get an export license from anybody else. The core of the unit is made of about 90 Department of International Trade staff, in green in this pictogram to show us in context. We carry out the licensing activities, international policy negotiations, we draft laws, carry out inspections to ensure compliance with our licensing system, as well as having a team of engineers and scientists who assess your goods. Working closely with the Foreign and Commonwealth Office, in blue in this pictogram, and the Ministry of Defence, in purple, we provide access to experts in global risks and requirements. Together, we form the Export Control Joint Unit. The unit can also call on many other government departments for their special advice as required. such as the National Cyber Security Centre, NCSC. The Export Control Joint Unit is here to ensure that laws that affect UK exports are applied legally and fairly. We're also part of the Department of International Trade, which is here to help UK businesses expand globally. So we have to balance things carefully, promoting global security through export controls, which can lead us to refusing certain applications, whilst allowing responsible exports. And if the balance appears off, we can and have been challenged in court. I'm told the laws control about 1% of all UK exports, and we assess these against 8 common criteria, which includes the UK's commitments to sanctions, embargoes, international agreements, and compliance with international law. For you and your organisation to become a responsible exporter, you need to know if your exports fall within this controlled 1%. And if so, what you need to do to ensure that your exports don't breach one of these criteria, so that we can give you your license as efficiently as possible. As export controls use a lot of terminology and acronyms that will be new to many of you, here are just a few of them, although I'll try and avoid using too many acronyms during this presentation. I could write pages of acronyms, such as NCSC, but I haven't, so hopefully this short list will be enough for today's course. WMDs are the first things that come to people's minds when we talk about export controls, so I've headed the list with the weapons of mass destruction. Seals, oils and O-gels are just 3 types of the many types of licenses we issue, and Michelle will go into more detail about these later. When I use terms like the order or the regulations, I'm referring to the current laws that are in place. Export Control Joint Unit, or ECJU, is part of the Department for International Trade, DIT, our government department. And when we talk about colleagues outside of DIT, refer to these as being in other government departments, OGDs. EUUs, end-use undertakings, and other forms of undertakings are a primary part of our licensing system, and will be mentioned later in the licensing section. No license required, or NLR, is a term many exporters are pleased to hear, as it means their activity or export is one of the 99% that aren't normally controlled by export controls. And CLC, controllers classifications, decide if your items are NLR or described elsewhere in the controls. You may have noticed a rather large elephant trying to muscle into the room at this point, so we'll deal with it now. At the time that this webinar is recorded in 2020, we are currently in a transition period whilst we negotiate a departure from the European Union. This means we'll continue to follow the EU Dual Use Regulation 428/2009 until the end of the year, and I'll mention this regulation again later. New guidance and helpful advice on the next steps has now been issued on our website. Search for Export Control Joint Unit to find that advice. Basically, the overall framework of controls for dual-use exports will not change, but there will be changes to some of the licensing requirements for UK exporters. The biggest and most significant is that after the transition period, you will need an export license if you're exporting dual-use items from the UK to the European Union, or the Channel Islands in some cases. And this license can only be issued by the United Kingdom. To assist this transition, the Export Control Joint Unit has published the Open General Export License for exports of dual-use items to European Union member states. This license also covers exports to the Channel Islands. If you already registered to use this license previously, you do not need to register again. Also, you do not use this license until the end of the transition period, as it covers transfers that currently don't need a license. This new export license will remove the need for you to apply for individual licenses and can be used immediately after the transition period, following registrations through SPIRE, our online licensing system. Conversely, your suppliers moving controlled dual-use items from the European Union into the UK will also need a new license issued by an EU member state. Fortunately, the European Council has put measures in place to add the UK as a permitted destination to the Union General Export Authorization EU001, which at the moment carries 7 friendly nations such as Australia, New Zealand, Canada, the US. This is again to minimize any additional licensing burden for those exporting dual-use items from the EU to the UK. Until this license in place, you will still need to continue to abide by Article 2210 of the European Union regulations. This article applies to items controlled by the dual-use list when they're being transferred between EU member states. Although a license is not currently needed to carry out this activity for most dual-use items, Article 2210 requires exporters to indicate to the recipient, probably your customer, that the items they are receiving are in the dual-use list. This then transfers some of the responsibilities for those items, and if your customer then exports those items outside of the European Union, they know they need to apply for a license in their member state. Please also ensure you'll sign up to our email service, also how you get our notices to exporters. And we'll keep you up to date with any changes to these arrangements and how they may affect your exports. I'll show you how to sign up to our email service at the end of this webinar. Now that we've dealt with the elephant and the background to today's webinar, what do you need to do as a company and entity to keep yourself and your business compliant? I'll be taking you through a journey today from the control status of the items, technology, some of the more obscure controls on trade controls, end-use controls, and sanctions, before handing over to one of our experienced licensing colleagues, Michelle Sullivan. Michelle will then briefly go through licensing and licenses and compliance. After all of that, I'll leave you with some guidance so your head will be swimming in the new processes which many have never seen before. So what's controlled? The intention of export controls is to restrict the destabilizing spread of conventional weapons, proliferation of chemical, biological, and nuclear weapons, and the missiles capable of delivering them. To this end, the UK is a founding member of several international organizations seeking to control the movement of different goods and technologies. And in the top left-hand side of this picture is the Wassenaar Arrangement. It's called this because it was first convened in Wassenaar in the Netherlands. It now resides as a fully staffed office in Vienna. 42 countries, including the UK, US, Japan, Germany, India, Russia, and many others, meet throughout the year to discuss the current and future risks of military and dual-use goods, software, and technology. Wassenaar is responsible for the military list and most of the dual-use list. The other 3 entities, the Australia Group, Nuclear Suppliers Group, and the Missile Technology Control Regime, are all responsible for specific aspects of the controls, mainly around items that could be used to make the weapons of mass destruction or the production of the missiles that can deliver them. UN Security Council Resolution 1540 requires that all states adopt and enforce appropriate laws to prevent strategically sensitive items going to non-state actors, such as terrorists, as well as other effective measures, including border controls and export controls. So we'll look at all of these different regimes, take all the pertinent controls, and distill them into a free-to-download 300-page document, otherwise known as the Consolidated Control List, which is available from our website. As mentioned before, Her Majesty's Revenue and Customs enforce export control law and advise me that only about 1% of all exports from the UK are described by this list. So this is your first challenge. Do I need a license at all? To further break down the controls, covering the consolidated lists, they're currently split into 2 broad groups. The yellow boxes cover UK national controls and the Wassenaar Arrangement's munitions list, which we call the military list. This is currently enforced through the Export Control Order of 2008, which sits under the Export Control Act of 2002. This is UK law and broadly means that any of the items listed in the order require a license for export from the UK to anywhere. This includes UK overseas territories such as Gibraltar and even the Channel Islands. However, read the controls carefully as there are many exceptions. The blue boxes contain non-military items controlled by other regimes and the rest of the Wassenaar arrangement. This is currently covered by EU Regulation 428 of 2009. This is why most of the items in the dual-use list do not currently need a license to be transferred between the EU member states. Much of the contents of the EU regulation will become UK law after the transition period, hence the need to use the Open General Export License for the EU as I previously covered. The first question an exporter must ask themselves when they're looking at their goods, software and technology is my item described by the military list? The military list is made up of 22 entries, including weapons, platforms, highlighted in bold on the screen, unfinished goods, specialist production equipment, software, and certain technologies. These items are found at the beginning of the consolidated control list. It's about the first 40 pages. And the term often used within these controls is, has the item been specially designed or modified for military use? And there are variations of that text. This is the text as per the original Wassenaar arrangement text, and it's the same approach shared by many of the signatories to it. The upshot is, if your customer or potential customer is military and you design something for them, then it is likely to be in this list. And once in the list, it stays in the list as the original design intent can't change, even though items previously used by the military are used by non-military entities. Similarly, just because a military is using an item typically doesn't change its original design intent. For example, a waste paper bin from a high street store being used by the military doesn't make that waste paper bin specially designed for military use, and so it's not likely to be in this list. The military list additionally describes certain equipment not designed for military use, such as hunting rifles, and we add in certain paramilitary goods, such as riot shields. If your item is listed in this list, then you may wish to record that for future use, as you need a license to export the item outside of the United Kingdom. If your item isn't described by the military list, then you need to assess it against the dual-use list. I have some examples of typical dual-use items on the screen. Dual-use items are normally non-military items that have significant potential military, weapon of mass destruction, or human rights use. These controls make up the bulk of the consolidated control list, and each control can be very different. So you need to read the controls that may apply to your item in great detail. However, as we're only controlling about 1% of all exports from the UK through these controls, these lists are very different to the commodity, customs, or tariff codes you're probably used to. We classify items not described by the consolidated list as no license required. So don't be surprised if after going through the military list and the dual-use list, you don't find your items in the list. However, other controls may apply to your items regardless of whether they're normally in this list or not, and I'll move on to some of those examples later. Oh, and just for clarification, there is no direct correlation between customs codes and the control lists because the origins are very different. As you can see here, this is a long list of dual-use items, so we split it into 10 categories. Each of these 10 categories are then split into 5 further subcategories, and it can get very detailed. So I'll leave you to download the consolidated control list off our website and see if your items are in it. And the titles of the categories should give you an indication of where you may want to start looking first. You are not required to come to us to make an assessment of your items against these controls, and most exporters do this for themselves. However, if you try to do this and you find you can't make your own assessment, then Michelle will mention later about how you can access our advice services, where you can request we carry out to 4 control list assessments for you for free. But we want you to try first so we can see where you're stuck, and please explain your workings out. And if you think you need a license, then apply and we'll make the assessment to make sure. But again, please advise us how you made your assessment so we can do our licensing assessment as quickly as possible. I'm going to take one particular example here, because the dual use list can contain some items that appear surprising at first glance. The example I'm using here is sodium fluoride. Let's make toothpaste. Why is it in the list? Well, the problem is that sodium fluoride is also used to make sarin, a chemical warfare nerve agent. So do we control toothpaste because it has sodium fluoride? Well, no. This is because when the regulations were debated at Australia Group, the issues were considered and a sensible decontrol was put in place. In this case, consumer goods are not controlled and toothpaste does not require a license. So please read through the dual use list, look for the decontrols, and say any issues, please come to us. Both military and certain dual-use software is controlled. These are under ML21 of the military list and subcategory D in each of the 10 categories of the dual-use lists. Also, information for the development, production or use of something that is in the control lists, and some very strategically important information, regardless of whether the items are in the list or not, is controlled in its own right, and we call this technology. Technology is mainly described under ML22 of the military list and some category E of the dual use lists. Here is a summarized version of what technology is controlled. And the double quotes mean that this is a defined term. Please ensure that you read the definitions at the beginning of the military list for military technology or any other defined military terms, and the dual use lists for the dual use technology and defined terms within the lists there. There are slight differences, so please read these to see how it applies to your technology, your software, and your items. You will also come across many exceptions. One example is that for information freely available off websites, handouts, etc., is considered in the public domain. It's a defined term, so please go and see that in the controls. And so stuff in the public domain typically doesn't need a license. Further technology guidance is also due to be published on gov.uk shortly. And you can request a copy of our technology webinar. I'll provide details at the end of this webinar of how you can request that recording. Once you know you're dealing with controlled technology, anyone with access to that information has the means to transfer it and export it. Each of these transfers could require a license, regardless of how the technology or software is transferred. Physical exports, which you can take with you on a flight, for example, could have you or your electronic equipment stopped at customs. And if you haven't got the appropriate license to hand, you may not catch your flight, or worse. And don't forget, once you've got such technology outside of the United Kingdom, how are you going to get it back from the nation you're traveling to? They may have similar laws to ours. We can only license your export from the UK, not what happens next once you've left the UK. Okay, so although traveling with technology is a risk, of significantly higher risk to individuals, companies, and academia is the electronic transfers of technology and software. We call these intangible exports. You'll see some examples of intangible transfers here, although I'm not sure how many people use faxes anymore. Emails are one of the easiest ways to export technology. It's a known threat, and you may be able to control it. But what of the video web conferencing tools that many of us are using today to learn? Do you talk to customers, suppliers, or students by a web conferencing application? Maybe one where you can share what's on your screen. If so, what's on your screen or on the wall behind you? If it's an export control drawing of an item that you want them to manufacture, test, design, etc., and your contact is overseas, then at that very point an export might have happened and a license may have been needed. It is important to point out that the risk also applies to talking to your own colleagues if they are overseas, or if you're overseas and access to such technology or software from the UK. Whether or not a license is required depends on where the recipient of electronic transfer is located, not their nationality or who they work for. So transfers within the UK to anyone else within the UK typically doesn't require a license. That's regardless of whether they are a UK national or not. It's not an export until it leaves the UK. To manage this risk, all personnel in an organization with access to controlled software and technology should be aware that the export controls can affect them. Maybe that's why some of you have logged in today. This is because Her Majesty's Revenue and Customs, the enforcers of this law, advise that all individuals are responsible for complying with regulations, in addition to the organizations they work in. Just be clear on this point, individuals and companies are equally open to investigation and potential prosecution if export control laws are broken. This applies to project managers, sales and marketing personnel, lecturers, students, and yourself. Another part of the order controls military goods that are being transferred from one third country to another, and there is a UK involvement. We call these the trade controls, sometimes known as trafficking and brokering. And depending on the trade category of the items, we break them down into categories A, B, and C. Many activities in the UK and some activities of UK citizens overseas can be controlled. These include, but are not limited to, arranging or negotiating contracts, arranging or providing freight or maybe transportation services, arranging intercompany transfers. Ownership is not of the controller. Maybe you do drop shipping. And the strictest controls apply to Category A goods. These are items of human rights or international prohibitions. Or you're exporting to sanctioned or embargoed destinations. Please visit our website for further guidance on these particular sets of controls because they are quite detailed. But you can note, these controls do not apply to imports or exports to and from the UK, imports and exports, nor do these controls apply to software or technology. Trade controls also don't normally apply to dual-use items. This is mainly a military control. The exception is unless there is a weapons of mass destruction issue. But we'd hope that if you come to us, if you're dealing with weapons of mass destructions, because most of those activities are going to be controlled, whatever it is you're doing. Other written controls come from sanctions, embargoes, and other restrictions. Gov.uk carries details of the latest restrictions by country, and each is different. Each is requiring a detailed review of the conditions to see if you are affected at all, and if so, whether you can even consider the export or trade. For example, some sanctions are all-encompassing, such as North Korea, and some are very specific, such as sanctions on certain individuals, or maybe certain equipment, like vessels for refugees. And the final set of controls don't have lists of items. It's more about the intent of an activity. We call these the end-use controls. These controls are rarely invoked, but applied where there is significant risk or knowledge that the otherwise non-controlled items are to be used for weapons of mass destruction purposes, also known as WMDs. WMD controls include chemical, biological, nuclear materials, and the missiles to deliver them, including unmanned air vehicles. This can be of substantial consequence to certain organizations, especially academia. Students from various listed nations may try to attend certain sensitive courses in the UK. And unlike the previous controls, the nationality of a person is now a factor. Other government departments and approvals may also be required, such as the Academic Technology Approval Scheme, ATAS. This is a requirement for certain non-UK persons to be able to study specific subjects in the UK. Details of ATAS can be found on the government's website, and I'll provide a link in the course notes which will be sent around after the webinar. And finally, there are military end-use controls that generally apply to non-controlled items such as a diesel engine for a commercial logging transporter, like the image on the left here, that are actually going to be installed or used to make a military item in an arms embargoed nation, like the Intercontinental Ballistic Missile Launcher, the ICBM launcher, on the right here, seen in North Korea. So with such complicated controls in place, you may expect that we prosecute a lot of people transgressing the controls. Fortunately, there are very few serious breaches for HMRC to deal with. Most minor cases are dealt with by warnings or fines, just like the approach used by the police in response to certain driving offences. But some offences can lead to full prosecutions, can result in unlimited fines, or up to 10 years in prison if serious enough. And HMRC have been known to make public announcements about these prosecutions of a warning to others. So I'll now hand you over to my colleague, Michelle Sullivan, an experienced licensing officer who also used to work on our helpline. So Michelle, what do exporters need to do once they've found they need a license?
Right. Sorry, just one second. Right. In order to apply for a license, you first need to know what types of licenses that we have. So, if you're exporting controlled goods, there are a number of different licenses issued by the Export Control Joint Unit, ECJU, for exports from the UK. These include Open General Export Licenses, OGELs, Standard Individual Export Licenses, SEALs, and Open Individual Export Licenses, OILs. I will explain briefly these different types of licenses and how to apply for them. OGELs. An Open General Export License are available for certain exports. These are pre-published licenses with set terms and conditions which you must adhere to. There are currently over 40 OGELs available which cover a wide range of circumstances. Some are for military goods and others are for dual-use goods. And a small number are also for both military and dual use. Being an OGEL holder can potentially benefit your business by saving you time and money. But before using, you will need to pre-register for each license you intend to use. You will also need to carefully read and understand the relevant OGEL that you intend to use. You need to make sure that you can meet all the outlined terms and conditions of the license. For example, you can only export to exact destinations allowed, or you keep the necessary records. To check whether there's an OGEL that covers exports you wish to make, you can make use of our OGEL checker. And as a registered OGEL user, you will be subject to regular ECJU compliance audits. You can read the guide on compliance and enforcement of export controls on the Gov.uk website. Standard individual export licenses. If your goods, technology, software, destination or situation is not covered by an OGL, you will need to apply for a standard individual export license. Seals are company and consignee stroke end user specific. These are quantity and value specific. You will need to provide supporting documents with all applications such as end user undertakings and technical specifications for the goods. Also, you will need to list all entities outside the UK and entities that are ultimate end users and third parties in the UK must be included on all seal applications. These could be agents, parent companies, other related companies, etc. Oils. Export Control Joint Units also issue a number of individual export licenses called oils. They're designed to cover long-term contracts, projects and repeat business. We have 5 predetermined templates available on Spire: dealer to dealer for firearms, cryptographic, hardware, software, technology, UK continental shelf for offshore installations, and media for journalists and aid workers, and the final one, through life support military goods. We also have tailored military and dual-use oils. This is a concessionary form of license, which is company-specific, but not necessarily end-user-specific, consignee. There is no set quantity or value of goods, although the conditions covered may be set on the license. And under an oil, you will also receive regular compliance audits from ECJU. Minimal support documentation is needed. You need it typically to establish a track record of exporting before you can apply for an oil, or have a strong business need. It should replace at least 5 seal applications a year. If you want to apply for a license, applying for licenses, you can also use our advisory service, but you will need to set up an account on Spire. Spire is our single online portal for most license applications, OGL registrations, and our advisory services. There are 2 types of registration: a web registration for individuals and self-employed, and a company registration. Company registrations are based on legal entity, which means all licenses issued under the head office company address. But by registering your company, you have company administrators who can control access rights to colleagues and link all company users to the same account. You also will get extra usage rights by being able to clone applications. Everything you submit on the Spire system, applications and supporting documentation, are uploaded electronically. And all licenses and letters from the advisory service are issued to you electronically via Spire, and the licenses are then linked to HMRC's chief system. Our advisory services, on Spire you can make use of them: the control list classification service, which would determine whether your goods fit within the controls, or the end user advice service, which looks at end users. You should note these are both advisory services and not licensing. For more information about these services, read the guidance on strategic exports and when to request a license on the GovUK site. Compliance and visits. You will need to ensure that you have a solid export control system and procedure in place in terms of record keeping, training and lines of responsibility. If a compliance visit finds that you are not complying with the terms of your license, you could face a penalty. Penalties range from deregistration of your license to fines or even potential prison terms if you do not adhere to your export control obligations. Hopefully I've covered that and you have the information that you need to move on to our website. I will now pass you back to Adrian.
Right, thank you, Michelle. So as you can see, we are here to help, and the Export Control Unit website contains a wealth of information to help you, the exporter. As well as guides and essential documentation, it contains our notices to exporters. These cover significant changes to legislation and licenses and keeps you informed. And one of the most useful services we provide is a free email service who advise when a new notice to exporters is published. Also when new training is available and anything we think is of significant interest to yourselves as exporters. To sign up to this free service, please visit our website and you'll find the ECJU mailing list about halfway down the ECJU website, and you can put in your email there. And finally, to help you stay compliant, here are helpline, email and telephone numbers, as well as Michelle's and my emails if you are desperate. But please note that the helpline, your case officer, especially for licenses, or compliance inspector to do with compliance issues and open general licenses should be your first port of call. And please contact my esteemed colleague and training manager, Denise Carter, if you need to access any of our webinars or wish to attend future training events. And you can always search on the internet for further guidance. So provide some terms that will help you to help you find that information you've been looking for, such as the consolidated control list I've been referring to. This will bring you straight to our CLC website, so yourself can download the book and have a look through it. Some guide documents from the Export Control Unit, the guide to the transfer of border control technology, and other guide documents are on there to deal with open general licenses and seal applications. And there's a cheeky plug there for Export Control Training Bulletin for when we're able to do face-to-face training. So, thank you so much for listening to our presentation today. And now it's time to get some of your questions. On the right-hand side of your screen, if you haven't found it already, you should be able to click on a panel, look for the small down arrow, term questions. And then you'll be able to ask us some questions. And Claire, Michelle, and I will then try and answer these over the next 10 minutes. But don't worry, if you get around to your question, we'll be reviewing all of your questions later. We get a full spreadsheet of them, and then sending out anonymized and grouped answers to the emails that you registered with. So Claire, what sort of questions have we had coming over the last 40 minutes?
Okay, Adrian, I think everybody's been listening really well to what you've been saying, and we've loads and loads of questions.
Oh, excellent.
I've been sort of like putting some answers in along the way, and so has Michelle, I've noticed. So I hope people have found those answers helpful. So I've tried to put them in various categories. I'm going to start with a question from Justine. Justine has asked, does selling X works negate the need for an export license?
Oh, this old chestnut. Okay. This is down to who does the law apply to. XWorks, I believe, is an Incoterm, which helps companies and shipping and agents and freight and those sorts of people move goods around. It is not the law. XWorks does not absolve you for getting an export license. The order does describe in detail who is responsible for getting an export license. There has to be somebody within the UK who is based in the UK who can get hold of that license. You can't pass that responsibility on to somebody overseas. So XWorks normally doesn't change who is responsible for the licensing.
Great stuff. Now, Trevor asked this question quite early on, and I'm not sure whether he got the answer. I mean, he probably did get the answer from what you said later on, but I'm going to ask it anyway. On dual-use items, if you're exporting them temporarily to Europe, what license should be in place post the 31st of December?
So sorry, just to clarify, was that dual-use items?
It's dual-use items that at the moment don't have any need for licenses.
So although they don't need for licenses, if they're going temporarily for their own use, then Article 2210 probably doesn't apply. If I go back to the slide here, post the transition period, and you need to check the terms and conditions within this Open General License. This Open General License should cover most transfers of dual-use items into the European Union at the end of the transition period. But please check the terms and conditions. And if there's any problems with those, please come back to us, because we can always feed this into the people who write these open licenses if there are things which we're missing.
Super.
And can I just, could I just confirm, Claire, did you say for temporary exports?
Yeah, this was for a temporary export into Europe.
So Adrian's pointed to the OGEL that hopefully will be in place after December. And we are interested in what's leaving. Usually import controls would not be relevant. So even though the license is there for permanent exports, once you export, it is classed as an export, whether it leaves the country or not. So you would use the same license and then the goods would be returned when ready.
Thank you very much for that clarification, Michelle. I've got a question for you now, Michelle.
Okay.
If I've received, if I've received a letter from Spire to say no license is required, can I use that for identical shipments to different customers?
Yes, you can, but you have to take into account when you asked us to, if it was to rate the goods, then we've said the goods do not come within the controls. You can understand that there are countries that you would send the goods to and there would be no concerns. If the goods are going to a country where there may be concerns, you may wish to use our end user advisory service, or if there's an urgent need to export, it might be just as easy to do a license, because you may have to wait 5 to 10 days for a response for us to tell you you need a license because of the end use controls. So when goods are not controlled, Adrian had a slide regarding end use controls. That would come into play where goods are not controlled but go into certain destinations.
Lovely. Thank you very much. I've got a question here from Masatika, who asks, what happened to the Export Control Organisation? Some people say ECO has replaced ECO.
I'll answer this one.
Can you pick that one up?
So I'm advised that legally the Export Control Organisation, which I joined over 20 years ago, still exists. It's part of the legislation to say the Export Control Organisation is the licensing authority. But under the last Strategic Defence Review, there were 4 joint units formed. And so the Export Control Organisation, which would have been the green area here, it's far too small to see, but you can see when you go around, when I send these around. That would have been the Export Control Organisation as was. But that term is slowly being phased out, and we're calling ourselves a joint unit because we're working so close with other government departments.
Yeah, hopefully that's clear. I've got several questions here, Adrian, about information technology and cloud servers. You love these, don't you?
We do an entire webinar on those, but I'll answer what I can.
We could do it you have done an entire webinar on these. So one here, do export controls, this is from Nicholas, do export controls apply only if the server of video conferencing is overseas, but all participants are in the UK?
So by the sounds of that, the tool they're using is overseas, but all the recipients are in the UK. That's an unusual scenario. So as I say, we will. There is a whole webinar which goes into this in some detail. But in the way that we approach technology and software, it's almost a case of where does that technology get seen. So for information which is going through routers, servers, and other systems overseas, provided nobody sees it overseas, it hasn't gone overseas. It has to come back. So to have a control, it has to actually meet somebody over there. Someone has to see it. But if nobody sees it while it's using this facility, provided people, even the administrators, don't see it, then it hasn't left the UK. Provided they monitor who's looking at that information outside of the UK.
Okay, that's really helpful. And as you said, there's a whole webinar on technology that we're hoping to get posted up. Some people have already been sent a link, the ones that applied for it, because there are so many questions here around when licenses are needed for such things as webinars and all of those things. I think it would be really helpful if we can get the link to that webinar that you did in May sent out to anybody that wants to know a bit more about the cloud and the technology and webinar and all that.
It is one of the biggest risks. So what we'll do is we'll link the webinar access to those people who've registered today as well. Yeah,
I think that would be fair, Adrian, if we did that, because I can see that a lot of these questions are actually quite detailed, and your guidance and your webinar pitched that up beforehand, so it should answer a lot of these questions.
I'd also like to just go back to I think it was your first question. I've been looking through the regulations, and it was about who is responsible for export licensing and XWorks and whether that applies. It's Article 27 of the Export Control Order of 2008. So that's Article 27 goes into who is authorised to get a license. So that's the law. So ignore XWorks and Incoterms.
Okay, no, that's really helpful.
I think we've got time for one last question.
One last question. What question should we... Oh, this is a real question for you, Adrian. What is the burden of proof on original design intent? What if there are no definitive records, but the first customer is military? And that was asked by Michael.
Right, this is especially true for people who are dealing with old equipment, some military equipment, and equipment which has been used by the military just after the Second World War. The history is lost on what its original intent was, what its design was. So it's case by case by case. What information is available, what's the likelihood. If there isn't enough evidence one way or another, then I would always advise a company to come in and ask us to make an assessment with you, and then we'll come to an agreement. If information or new information comes to light further down the line, then we can then change the control status accordingly. But it's much better to say that we controlled something and then found it was decontrolled and had their arrangement, or we've decontrolled it in agreement with the Export Control Joint Unit, and now we've found new information, but we worked on the best information available. So do your best, work with us, and we'll come to an agreement on it.
Okay, I think that's really helpful. I'm just going to have to ask this question. Will we be able to understand the category 5D002?
So 5D002.
And the difference between 5A002. Somebody's getting very specific here. It's Cindy, and she's saying, what's the difference between 5D, a category 5D, and a category 5A?
So this is really getting into the weeds.
It's really getting into,
Yeah, so category 5 is one of the 10 categories on the jury's list. Category 5, and when the last number is a 2, usually means it's to do with information security. A means it's equipment, so you'd find pieces of like routers, servers, switches with an encryption capability will be 5A, whereas 5D for Delta will be software, and that software can often be put onto servers, routers, laptops, and such like. So one is software and one is hardware.
Okay, that's really helpful. I know you said you only wanted one more question. I've got 2 points to make, and I'm going to make.
Okay.
So we've had a couple of questions around banks and finance institutions. I suggest with these ones that we probably take these offline. So, for instance, I've got a question here from Lloyd, and I had a question from the Pendu. So can we give you answers to these about controls on for banks and financial institutions, and we will answer those inquiries. And then there's a few questions, and I want you to know that we've picked them up. There's a few questions around conversions of US controls to EU controls. Now, this is something, EU code, so this is something that we don't, we wouldn't be answering on, but we can we can take these questions and we can put you onto somebody that can help you in terms of understanding US EAR and ITAR, how that all applies. So we'll take those questions and put some answers together for those of you that want to know about US controls.
Yeah, and I just saw flashing up there as questions about end users. That is the biggest issue we have, and I just want to do a plug for a course we'll be doing. I think it's on the 29th this month, where myself and Michelle will be going through license applications and issues, and one of the things we'll be going through in great detail is who is an end user, a third party, a consignee, and ultimate end user. So please look out for your emails, see that webinar, and we'll be going into that in much more detail.
Yeah. Okay then, Adrian. I think that's brought us up to time, hasn't it?
Yeah, I think we need to hand back to Corinne.
Hand back to Corinne now.
Perfect. Thank you so much for that. One final last note from myself is when you leave the webinar today, you'll have a survey. We'll really appreciate it if you can fill that in. It helps provide feedback to us and improve these events going forwards. So once more, thank you very much for joining, and I hope you enjoy the rest of your day. Thank you.